So up until last Tuesday, I was going to plan on speaking on the upcoming January 1st, 2025 compliance for pre-existing entities with the Corporate Transparency Act. Last Tuesday, December 3rd, a U.S. District Court in Texas issued a nationwide preliminary injunction against enforcement of the CTA and a stay on the reporting obligations. Rather than go through the bulk of the presentation I had, we're going to switch gears a little. I'll go over briefly the summary of the main rules and then also speak more about what the injunction and the stay means kind of going forward. The CTA was passed in 2021 as part of a defense authorization bill. It was very bipartisan at the time. I think some primary people were very supportive of it included Elizabeth Warren and Marco Rubio. It took, I guess, 4 years for the rules to come out. You started to have to comply starting in January 2024 for entities that were created in January 2024. You had 90 days from the date of formation to comply with. The cliff that everybody's talking about for the January 1st, 2025 deadline is for pre-existing entities. So entities that existed prior to 2024 had to comply with the reporting obligations by January 1st, 2025. The reporting that was required was for each reporting company, and a reporting company is in general going to be corporations, LLCs, partnerships, pretty much any entity that you form by filing something with the Secretary of State or a similar office. You have to report the exact name of the entity, the EIN or other kind of to identifying kind of tax ID, and then the commercial address of the company. You also have to report beneficial ownership. So unlike a lot of other similar rules, beneficial ownership is rather broad for purposes of the CTA. Beneficial ownership means both people who own 25% or more of an entity, but also people who have quote unquote substantial control of an entity. So take a simple LLC, two members owning it 50-50, both members are going to have to report under the 25% or more ownership prong, but if there's a separate manager, that manager is also going to have to report because their information is going to have to be reported because they are somebody with substantial control. For each beneficial owner, this is where it gets a little harder and more cumbersome. You have to report their full name, their date of birth, their current residential address, and you also have to track down a driver's license or passport and upload that with the filing. For entities that are formed in 2024 and after, you also have to identify what's called a company applicant. A company applicant is basically the person who actually formed the company. So in most cases, this is not going to be the client. It's going to be an advisor. A lot of times it's somebody from CNL. It's me a lot of times. There has to be at least one company applicant. There can't be more than two. So what they want you to report is the person who actually did the filing, so physically kind of went to the Secretary of State and said, here, file this. That may be somebody from a law firm or another advisor. That may be a person who's at CSC or CT Corp, one of the other filing services that we often use. So that's one company applicant. The other company applicant is going to be the person who's responsible for basically filling out the information. Not necessarily directing the information, so it's not the client, but the person who kind of took the decision-making in terms of how you fill out the articles of organization or certificate of corporation or what have you. That was one of my frequently asked questions was clients had continuously come to me and said, well, am I the company applicant here? And the answer is no. It's usually going to be somebody like me. With the company applicants, you have to report, again, name, date of birth, but rather than residential address for the company applicants, you had to report the commercial addresses. Entities that existed before 2024, filings were going to be due January 1st, 2025. For entities that were formed in 2024, you had 90 days from the date of formation to form, so many of you may have already had to have filed. For entities that were going to be formed in 2025 or after, the rule was going to be that you had 30 days after the date of formation to file. So going back to the case, the judge issued a nationwide injunction, so it applies to everybody everywhere. There was a previous case in Alabama that was a specific injunction for the specific plaintiff at issue. There were various cases throughout the fall and the summer where other district courts had looked at this and they had said that the Corporate Transparency Act was okay, but it only takes one district court to issue the injunction. That's what happened here, so it applies nationwide. The stay in the case refers just to the January 2025 compliance date, which again isn't necessarily the right reference. When the case came out initially, everybody was wondering, does it just apply to pre-existing companies that have to file by 2025, or does it apply to all companies that are formed after that date, which have a different compliance date, again, 90 days or 30 days after formation? I think the general view is, and FinCEN has certainly taken it this way, is that it is a blanket injunction of everything involving the Corporate Transparency Act. FinCEN did appeal, and they have issued a response. And the response is twofold. One is they recognize the order. They have said they will comply with the order. They have also said that they're not closing down the website, and you can voluntarily file. The injunction and stay are preliminarily only. Again, not just in this case, but kind of going forward, there's a lot of different things in the pipeline. So I think everybody is generally kind of wondering, well, what's going to happen? Looking at kind of various commentary, talking with people internally and other colleagues, kind of how has the market responded? And it seems to have been, and again, just happened a week ago, but it's been kind of all over the place. Some people have just continued on and said, well, I'm going to file. There's no reason not to. I think it's going to get overturned very quickly, or the stay is going to get overturned very quickly, and it's going to be back required to file. Other people have said, I'm going to throw this in the trash. I don't have to look at it ever again. Other people have been more measured and said, well, let's just monitor things as we kind of go forward. The advice that we've been giving to clients, again, this past week has been more kind of tailored to this specific question, which I think is, or a specific client, which I think is kind of the right answer here. I would put people in three buckets. One bucket is people who've already filed. I've had a number of clients come to me and say, well, do I have to do anything now because I've already filed? Maybe I filed in September because I was ahead of the game or I'd formed the entity. And the answer is no, you don't have to do anything. That also means you don't have to file updates. The CTA was a one-time filing. It was not an annual requirement that you had to continuously kind of reaffirm your information, but there was a requirement that you had to tell FinCEN when any of that information changed. So the injunction does mean that to the extent you've already filed, you're also under no obligation, at least currently, while the stay is in place, to tell FinCEN that something's changed. Say a member changed, you got a new driver's license, somebody moved, et cetera. Second bucket is kind of I would say the clients who had a relatively straightforward or simple reporting scenario. Again, going back to, say, you formed an LLC for a family to own a house. There's a husband and wife. Maybe one of the children is a manager, so you have at max 2 or 3 people that you have to report. They all live under the same household. They're all easy to get at. If the rules came back in play, you could put things together in a relatively short order. Basically, my general view is if it would take you less than a week and an hour of work to get the report ready, then I've been telling clients to just wait. Just monitor things, but there's no real reason to pre-fill things out. You know where the driver's license are. You know who the members and the beneficial owners are. If it comes back, it's easy to kind of get back in gear and get the filing done on time. The third bucket is the clients who have more complicated structures. Either they don't know who the beneficial owners are, or they have beneficial owners that are hard to track down. Everybody here has probably come across situations where you go back and look at the LLC or the corporation, and it's not really clear because of bad record keeping or because of uncertainty and kind of how things were issued or who exactly owns it, but kind of who is the beneficial owner. There is no real reason to stop that process, and to the extent the clients are amenable, we've been telling them to go ahead and, hey, this has value added anyway to identify who actually owns and manages your company. there's no real reason not to stop that process. That is somewhat capital intensive, somewhat time intensive. It's very possible that if this got overturned, FinCEN is not going to extend the dates by that much, if at all. Just the tone of how they've responded to the act, the fact that they're still submitting voluntary filings, et cetera, kind of leads me to believe that if this got overturned quickly, there's probably not going to be a lot of wiggle room to get back in gear. So you don't want to get caught flat-footed there. The other scenario is if you got a minority owner who you haven't seen for years and they live in Texas, you still should probably be tracking them down. Maybe you don't ask for their driver's license yet, but at least have them know that you may need their information sooner rather than later. The reporting obligation is on the reporting company. So it will be up to the persons in charge of the company to go and find these people and get up to speed when they report.